Good afternoon, everybody. Welcome to LCF Law's e-commerce compliance webinar as part of the Leeds Digital Festival. Hope everybody's well. So my name is James Sarjantson. I'm a partner in the commercial and digital team here at LCF Law in Leeds. Also presenting with me today is my colleague Tom Taylor, who's also a member of that team, the Leeds office of LCF Law. As we go along, do feel free to post any questions in the Q&A section in Zoom. We'll try and pick those questions up at the end of the day, sorry, at the end of the webinar. We are being recorded apparently today, and we're going to be putting this on the LCF YouTube channel towards the end of the day. We're booked in for about an hour, but we'll make sure that we finish well within that, including time for questions. So I appreciate you're in the middle of your working day, so we'll crack on with the webinar. Devin, if you could put the slides up then, please. So, question is, what are we going to talk about? Well, if you're selling online, we're going to try and cover the key things that you need to be thinking about on your website in order to stay compliant. Setting up an online business is pretty easy. It's pretty quick, it's pretty easy these days. Probably never been easier to set up a business and reach a mass audience as it is at the moment. Maybe because of that, some people think that selling online is still a bit like the Wild West. Of course it isn't, never has been. But you know, there's actually a large swathe of consumer protection legislation protecting online buyers, particularly where those buyers are consumers. Obviously, what we mean by that is people who are buying for their own personal purposes rather than buying anything on the internet for their business. So what we're going to do is we're going to sort of run through some of the key rules around online selling, which will impact upon what you actually put on your website. For that purpose, we're going to touch on some of the key rules. We're going to touch on data protection issues. We're going to touch on cookies. We're going to touch on some online marketing. It's a big issue. It's a big topic. So we can only really just touch on things. So if there's anything you want to explore in any more detail, do feel free to contact either Tom or I after the webinar. So, there we are. Okay, so what are the key rules that I'm talking about? Well, there's three key rules really in respect of online selling. The first are the consumer contracts regulations. So these used to be known as the distance selling regulations. They've been established for about 20 odd years. They first established the key principle that if you are a consumer and you're buying online, you can return products that you bought online, whether or not those goods are faulty. And that, of course, was quite groundbreaking really at the time. Obviously that period is 7 days from having purchased the goods or services. It's now been extended to 14 days. But that whole right of unconditional return is still a key plank of online consumer protection to this day. The second key piece of legislation is the Consumer Rights Act. So the CRA essentially just updated and consolidated quite a lot of existing consumer protection legislation, which was floating around in different pieces of legislation. And that introduced the concept of digital content as a category that you could buy online. So music downloads, film downloads, etc., as distinct from the more traditional legal concept of either goods or services. And Tom's going to talk about that in a bit more detail later on. And finally, there is the Consumer Protection from Unfair Trading Regulations, otherwise known as CPUT. Now, what CPUT does is it basically puts in place a blanket prohibition on misleading or aggressive sales practices, where, as a result of those misleading and aggressive practices, customers might be deceived into buying something that they wouldn't otherwise buy. essentially, it's kind of not giving consumers the right information to make an informed buying decision. So because misleading and aggressive sales practices is quite vague, there is actually a specific list in CPUT of banned practices. But so by way of example, you can't falsely state that a product's only going to be available for a very limited period of time in order to just pressurize consumers into making a buying decision that they wouldn't otherwise make. So these kind of referred to as urgency claims can take a number of forms. So for instance, if a trader falsely tells consumers that prices for a product will be increased in 24 hours time, when in fact that is not the case. Often these kind of things are accompanied by fake timers, aren't they? That emphasize that countdown of time. Another example might be a claim that a special offer might end on a specific day when in fact it won't. Deal must end tonight. We've seen those kind of claims. Or it might take the shape of a misleading claim around stock levels. Hurry, low stock, or low stock, only 5 items left. When in fact there isn't a stock shortage at all. Or if there is, the stock's going to be replenished in the next couple of days in a normal course, and you're not going to notice any difference as a consumer. All these things are about basically traders making untrue statements, giving consumers a false impression that they need to act quickly in order to avoid missing out. These are sometimes known as dark patterns, essentially the use of online infrastructure or online design to lead consumers into making certain decisions that they wouldn't otherwise make. And this is relevant because the Competition and Markets Authority is currently pursuing a program of enforcement specifically targeting dark patterns. There's a current investigation against a company called Woucher, which is a deal of the day website. They're currently being investigated by the CMA for this kind of dark pattern. And the Competition and Markets Authority do actively enforce these things. The jeweller H. Samuel, who I'm sure a lot of you will know, so they were recently fined £60,000 when they admitted misleading customers about the price information that they presented online. So, this is not just theoretical. This is sort of this is happening live, and this is relevant. One point that I wanted to mention in the previous slide but forgot to is, why does this actually really matter? As lawyers, we can talk about pieces of legislation, all that kind of stuff, but why does it matter in real life? And I'm also conscious that finding examples of non-compliance in some sectors online is actually relatively easy. So why does it matter, and why are we talking to you about it? Well, the answer is that these laws are enforced by the trading standards, but also the Competition and Markets Authority. And the Competition and Markets Authority are going to get very shortly very significantly enhanced enforcement powers to enforce breaches or to tackle breaches of consumer law. So there's some law going through Parliament at the moment, likely to come into force next year, which will give the CMA the right to impose fines of up to £300,000, or if higher, 10% of global turnover. So that's a very, very significant potential fine. It's the kind of attention-grabbing headline fines that we saw when GDPR came into force 5 years ago. And it was really those enormous potential fines that forced GDPR into front and center of boardrooms up and down the country. And it might well be that the level of these potential fines could do the same for online consumer protection. The other point to make, and this is no less important, is that breaches of certainly some consumer protection legislation can constitute a criminal offence, which in serious cases is punishable by imprisonment as well as fines. And it's not just the company that commits these offences that could be liable for the criminal acts. potentially directors or managers of those companies who've been involved in that decision making. The decisions have been with their consent and they've been involved in it. They can also be personally, criminally liable for those breaches of consumer protection law. So it's really important that if you've got an online business, you need to know what should and shouldn't be going on your website. So now I've scared everybody to death. What I'm going to do is I'm just going to hand over to Tom, who's going to talk in a bit more detail about the kind of things that you would actually expect to see on your website. Devin, if you could hand over to Tom, please.
Hello, everybody. My name's Tom, and today I'm going to be talking to you about consumer protection legislation, you lucky people. So, as James has already said, and as you can see on the screen, if you are selling goods, services, or digital content online to consumers, the law provides greater statutory rights for those consumers than it would have if you were selling to another business. So basically by that, we mean if you're selling your goods, services, or digital content to somebody who's not using that goods, services, or digital content in the course of their business, then they have greater statutory protection. If you're selling to tradespeople or if you're selling to customers, then these next few slides are unlikely to apply. But I would assume that most people on this course or on this webinar will likely be to fall into one of these three categories. Okay, so before you even enter into a contract with your customers, under the consumer contract regulations, there are certain information that you need to provide to your consumers before the contract is formed. On the slide, you can see a number of different requirements. I won't go through all of them, and this is not an exhaustive list. However, the key points that I would point out to you would be, obviously, you need to say who you are and what your contact details are. You need to give the total price of your goods, services, or digital content. And if it's the case that you're selling something where you're not able to give the total price, you need to give them the method by which the total price can be calculated. This would typically be found on your website, of course. The other key points that I would point out is at the end, you can see it says information about the consumer's right to cancel. More on that in a moment. And a model cancellation form. This is a form that you are required by statute to provide to your customers to give them the right to cancel their contracts with you. In my experience, it's very rare that I see people actually providing customers with access to this form, which is technically a breach of the regulations. So why is this important? Well, in short, if you don't provide this information required under the consumer contract regulations, then the consequences for you could be that you're not entitled to charge for any work undertaken or goods provided. You may have to refund any monies that you've already received, and it is a criminal offence. So you could receive a criminal record and you may be liable to pay a fine. It's therefore very important to make sure that you are compliant with the consumer contract regulations in terms of the information that you are providing. So on the previous slide, I touched on the fact that when you are selling goods, services, or digital content online, consumers do have the right to cancel that contract during the cancellation period, and they don't have to give you a reason why they are cancelling the contract. Now, the rules around this differ depending on the type of contract, and the cancellation periods differ accordingly. So if you're selling goods online, then your customers have 14 days from the date that they take possession of the goods in which they may cancel the contract. If you're selling, or if you sell multiple goods under one order, it will be the date 14 days from the last goods received by the customer. And if the customer does cancel the contract when they're selling goods to you, then they must return those goods to you within 14 days. Now, if you're selling services online, the customer can cancel the contract within 14 days after the day in which the contract is entered into. And you shouldn't really provide services to the customers within the 14-day cancellation window unless they explicitly request otherwise. And if you do provide the services within those 14 days, the customer does still have the right to cancel the contract, but you can charge them on a pro rata basis for the services provided. So, for example, if you provide the services immediately and the customer cancels within 5 days, you can still charge them for 5 days' work. Digital content works similarly to the sale of services. So a customer can cancel a sale or a contract for digital content within 14 days of the date that the contract is entered into. If they want the download within the first 14 days, then they must explicitly acknowledge that they will lose their cancellation right. And if they refuse to waive this cancellation right, then they cannot download the content until the 14-day period has ended. Now, obviously, you don't want your customers to cancel their contracts with you. So good news, there are certain circumstances where the right to cancel does not apply. Again, you can see on the slide that there's a list. I'll just pick out the key ones for you. So if the value of the contract is £42 or less, then your customers don't have a right to cancel. If you're selling customized, bespoke, or personalized goods, your customers do not have a right to cancel. So an example of that would be if you're selling watches online and your customer Dave wants to inscribe the name Dave onto the watch, Dave then cannot cancel the order. And the reason for this is quite simple. It's much harder for you to resell a watch that's got the name Dave on it. You could basically only sell that to other people called Dave. Other key points that I point out, customers don't have a right to cancel if they're purchasing something that is unsealed and not suitable for return due to health or hygiene purposes. So if you're selling underwear online and the customer wants to return it to you, they can't do that if they've broken the seal. Finally, I point out goods which are liable to deteriorate or expire rapidly. So typically that would be foodstuffs. If your customer purchases, for example, fresh fruit or meat, they can't then receive the goods and cancel the contract because the sell-by date will have passed. However, please be aware that if they're purchasing food with a long expiry date, maybe dry pasta or olive oil, then they may still have a right to cancel. And not only do your customers have a right to cancel, they do have a right to be refunded everything that they've paid to you, I should say, including any delivery costs. However, please note the following. So, although you have to refund cost of the goods or services and delivery costs, you only have to refund standard delivery costs. If your customers request express next day delivery, for example, and are willing to pay extra for that, you don't have to pay or you don't have to refund the express delivery. So, for example, if your standard delivery charge is £5 and your customer pays £10 for express delivery, you don't have to refund them the £10. You only have to refund them the standard £5. Equally, if your customers handle the goods in a way that perhaps damages them and diminishes the value of those goods, you don't have to refund them the full amount. You can refund them, or you can deduct an amount commensurate to the amount that the goods have been damaged. Now, your terms and conditions should set out that your customers have to pay for the costs of returning the goods to you. So therefore, you don't have to refund those. There are certain exceptions to that. For example, if you're selling goods that are not easy to return for your customers. For example, if you sold a sofa online, customer can't return a sofa in the post, so you may have to pay the cost of going to pick that up. Finally, and as previously stated, if you're selling services and your customers cancel during the cancellation period, you can still charge them for the work that you've done on a pro rata basis. Okay, so we've covered the fact that you have to refund some money. When do you have to refund it? Well, you have to refund it without undue delay. And in any event, if you're selling goods, you have to refund it within 14 days from the date on which you receive the goods back. And if you're selling services or digital content, then it's 14 days from the date that you were informed that the customer wished to cancel the contract. Some final key points to note, just in terms of consumer protection legislation. If you have to pay a surcharge because your customer has, for example, used a credit card, then you are able to pass on that surcharge to your customer. However, you're not allowed to charge them more than the amount you're actually having to pay for that surcharge. Equally, under the provision of services regulations, you must provide your customer contact details, and you must have a consumer complaints process by which you handle consumer complaints promptly. And I'd specifically point out, because I often see that this is the case, if you are a registered company, you must provide details of your registered company name, registered address, company registration number, and where you are registered. It's quite surprising how often you can't see that information on a website. Okay, so we've discussed the information that you need to provide to your customers prior to entering into a contract with them. And for the most part, this information can be provided to your customers by way of a set of terms and conditions. So terms and conditions are not only important for ensuring that you comply with consumer protection legislation, but of course, they are also the legally binding contract between yourself and your customers. And having a bespoke and comprehensive and incorporated set of terms and conditions can save you time, money, effort, peace of mind, and protect your business. So allow me to ask a rhetorical question. Does anyone here actually read terms and conditions? No, of course you don't. Nobody does. I write terms and conditions for a living, and I can honestly say I've never once read Amazon's terms and conditions when I've purchased something on their website. However, even though in practice nobody reads them, in reality, just as long as those terms and conditions have been validly incorporated into your contracts with customers, then those terms and conditions are legally binding. So one of the key issues that I see is that people will have a set of terms and conditions, but they don't adequately provide those terms and conditions to their customers, and therefore they cannot rely on them. So a good example of this is recently there's been a case involving the national lottery operator Camelot. Camelot have an online instant win game, and a customer of theirs was playing the game, and something popped up on their screen saying that they had won £1 million. Very nice for them. The customer put in a claim to the High Court for this amount of money, claiming that they were entitled to £1 million. And Camelot refused to pay out, arguing that the pop-up that the customer had seen was actually a coding error, and that, in fact, it says in Camelot's terms and conditions that this pop-up does not constitute a win. So the key question became, were these terms and conditions validly incorporated into the customer's contract with Camelot? The judge found that because Camelot had a series of mechanisms, drop-down terms and hyperlinks, that the terms and conditions had been validly incorporated because the customer had accepted them prior to playing the game. And that saved Camelot £1 million. Similarly, in a similar case, Betfred were forced to pay out £1.7 million because the customer in that case had been able to go on and play the game without having to accept the terms and conditions beforehand. So it's very important that you make sure that your terms and conditions are presented to your customers prior to them entering into the contract. If you provide your T's and C's to your customers after the contract has already been formed, and if you're an e-commerce business, that's likely to be around the time that they pay you for your goods and services, then your terms and conditions are unlikely to have been incorporated into your contracts, and you may not be able to rely on them. This is on the basis that your customers can quite validly say that they weren't aware of your terms and conditions, and therefore they have not agreed to them. It's therefore important that you require your customers to actively accept the terms and conditions, either by way of a tick box mechanism or pressing an accept button before the customer is permitted to proceed to enter their payment details and complete the order. So in addition to providing your T's and C's to your customers before the contract is formed, you also need to provide it to them in what we call a durable medium. What is a durable medium, I hear you ask? Well, it is providing the T's and C's in a paper form, email form, or some other mechanism which is personally addressed to them, which they can refer to at a later date. This durable medium must be provided within a reasonable time and in any event no later than the time of delivery of the goods or before performance of any service. Top tip, most of you will be sending a confirmation email to your customers in order to confirm the order. My tip would be to attach a PDF copy of those T's and C's to ensure that you comply with this legislation. Okay, one final slide that I want to talk to you today. We've discussed your terms and conditions, which is your legally binding contract with your customers. There's also something called website terms of use, which is a separate document, which is also very important for you to have. And what this does is it sets out the terms upon which your customers can access and use your website. This is important because it sets out the terms upon which your visitors may use the content on your website. Normally, this is limited to a right to print out or use extracts from the site. And on this, you should state that all of your rights, including your intellectual property rights in the website, belong to you. You also want to impose obligations on your customers so that they can't post anything illegal or harmful on your website, as in addition to any reputational damage that could cause you, you could become liable for that content, for example, if it infringes any third-party intellectual property. One final point, it is critical for you to disclaim any liability for the content or performance of your website. You don't want to be in a situation where your visitor relies on that content and then tries to bring some sort of claim against you for that incorrect content. You want to avoid any obligation to ensure that your content is correct and is up to date, as the task of checking and updating all this content is onerous and time-consuming. That's all the time that I have for you today, so I'm going to hand you back to James to continue the rest of this presentation. Thank you very much.
Thanks, Tom. Okay, so in this final part of the webinar, I just want to touch on some of the other key compliance features that you'd expect to see on an online seller's website. And the first point relates to data protection. Now, of course, data protection is a massive issue. You'd need a whole series of these webinars just to scratch the surface of it. So let's just focus on the minimum data protection notices that you'd expect to see on an online seller's website. And they are probably these three things. So at the point that you're actually collecting personal data through a website, so on an inquiry page, on a purchasing page, when you get in the consumer's details, there should be at least a very short privacy notice. There should also be a full privacy policy, setting out what data you collect, etc., which I'll talk about in a moment. And you'd also expect to see a cookies policy and a cookie banner. Now, under data protection legislation, by which I mean the Data Protection Act 2018 and the UK version of GDPR, there is a core requirement of transparency when you're dealing with personal data. And what we mean by that is basically being transparent with individuals as to whether you're collecting their personal data and what you're doing with it. However, those requirements are quite extensive. So at the point of actually collecting the personal data, so as I said, on a website inquiry page, or when the consumer's putting in his details to purchase a product, you can only really provide a very brief privacy message at that stage, and then link to the full privacy policy. In terms of what that privacy notice should look like, well, as with all things GDPR, there isn't really any one size fits all for all of this, but just a line as short as we collect and use personal data that you provide to us in accordance with this privacy policy, and then linking there to the privacy policy, that should really suffice. So just moving on to the actual privacy policy itself. This policy should be available, as I've just said, as a link on any page where you're actually collecting personal data from your consumers. You should also generally have it as a prominent link on the homepage of your website. So at all times, it's easily accessible to your web users. So what should the policy include? Well, there's a number of key requirements. Firstly, who are you? What's the details of your organization? How can people get in touch with you? Who's your data protection officer, etc. Secondly, what information are you collecting? What are you actually processing? And most importantly, what is the actual legal basis for that processing? Now, this part is absolutely fundamental. But often, when we see privacy policies, particularly those that haven't been professionally drafted, this is where we see significant non-compliance. There are 6 lawful bases on which you can process personal data. And for most commercial businesses, only 3 of those are ever going to be relevant, really. And those 3 are, firstly, consent, secondly, legitimate interests, and thirdly, performance of a contract. And you need to identify which of these 3 lawful bases you're actually relying on in respect of each category of personal data that you're collecting and processing. Again, I don't want to dig into too much detail because that's for another seminar on another day. But if you are relying on legitimate interests as a lawful basis, and let's be honest, most businesses should be heavily relying on this because it is probably the most useful lawful basis, then you'll also need to identify in that privacy policy what that legitimate interest actually is. So some of the key things that the policy needs to cover, you need to say who you might transfer the personal data to, whether you intend to transfer it outside of the UK. If you are, there's only a small number of lawful transfer mechanisms that you can use. You need to identify which of those transfer mechanisms you're going to use. How long you keep the personal data for. This is probably one of the hardest ones to nail down, and often we see this section being slightly fudged somewhat in privacy policies. But if you can't nail down a time period, then you can at least identify the criteria that you might use to establish a period within which you might keep personal data. For example, 6 years after the end of a contract, just to make sure that you've got the information to cover off any potential legal action. And finally, you also need to set out the data subject's rights, so the individual's rights. You need to describe what they are in your privacy policy. So, for instance, every individual's got a right to ask a company to give them details of their personal data that they are processing. You've got to set those rights out in the privacy policy. There's quite a lot to actually cover, and all of this assumes that your use of personal data is actually fairly simple. It doesn't take into account any processing of special category data like health data or data about political affiliations, etc. It assumes you're not processing personal data relating to children or engaging in any automatic profiling, etc. As I mentioned previously, with post-GDPR, there isn't a one-size-fits-all for any of this, and privacy policies can't just be cribbed from a competitor's website for the simple reason that one business will collect different data to another business. It'll do different things with that data. It'll share it with different people. So it needs to be bespoke. Really, it needs to be professionally drafted. And even then, only after a business has undertaken some kind of audit to identify what information they actually have and what they do with it. You may well have done that around 2018 when GDPR came in, but things change, what you do change, processes change, etc. It might be worth looking at that again. So just moving on to cookies. And of course, by cookies, what I mean is the small text files with small pieces of data that essentially allow a website to recognize an individual user of a website. When you're using cookies on your website, all of those cookies need the user's prior consent. The only exception to that is what's known as essential cookies. You don't need prior consent and you're using essential cookies. And by that, I mean cookies that are essential for the good operation, the normal operation of that website. So a good example of that is the cookie that sets out what is in a shopping basket online. Clearly, a user will navigate across the site, will go through different pages, but at all times, the shopping basket in the top right-hand corner of the screen will remember what is in that basket. So that is an essential cookie. You don't need prior consent to that. What's an example of a non-essential cookie? Well, Google Analytics is a good example. That's an analytical cookie. It's not essential for the operation of the website. So technically that requires prior consent if you're going to use it. And that prior consent is usually sought by a cookie banner or something similar on the homepage of the website when you first visit it. Those cookie banners should give the user the option to either accept or reject any non-essential cookies. Again, it's relatively easy to find some non-compliance with these requirements, but it's worth noting that even somebody like Google have recently been forced to put a blunt opt-in or opt-out of cookies on their cookie banner after the Information Commissioner's Office threatened to fine them if they didn't do that. And because we're talking about consent here, consent to non-essential cookies, that consent needs to be actively given. So the old pre-ticked consent boxes shouldn't be used, and the old wording of by continuing to use this website, you're consenting to our use of cookies, again, shouldn't be used. So that cookie banner would generally link into a more detailed cookie notice on the website, which will provide clear information about what cookies are actually on your website, what they do, are they essential, are they not, how long they last for, are they just on a particular session, or do they last beyond certain browser sessions. And again, that should be a kind of visible policy on your website. So the final thing I wanted to talk about or touch on is around email marketing to consumers. You know, I'm aware that most online sellers will rely quite heavily on email marketing to consumers and potential customers. However, the important thing to remember here is that any unsolicited or unrequested email marketing to consumers requires their prior consent. Now, this is as a result of some legislation known as the Privacy and Electronic Communications Regulations, PECR, which kind of sits alongside the Data Protection Act and the UK GDPR, although it was actually brought into force quite some time before GDPR. So rather unhelpfully, its definition of consumers is slightly different. But the key point is this requirement for email marketing to consumers where it's not being solicited, where it's not being asked for, to have prior consent. And of course, in the post-GDPR era, consent is actually quite difficult to get. Consent needs to be freely given. It needs to be fully informed. In other words, you need to know exactly what you're consenting to. It needs to be specific to a particular type of contact from a particular entity. It essentially needs to be an unambiguous expression of somebody's wishes. That's actually quite hard to get. So it's useful to know that there is actually an exception to this requirement for prior consent, and that's what's known as the soft opt-in. Now, this soft opt-in essentially applies, and when it applies, it means that you can provide email marketing to consumers when it hasn't been specifically asked for. And it applies where you've obtained that consumer's contact details in the course of a previous sale to them. So this is why you'll know this yourselves from your own online buying, that when you buy a product from a particular website, you'll then get inundated with marketing messages from that website. That's because they are utilizing the soft opt-in. Now, if you are going to utilize this, and it's a very good idea to do so, you've got to essentially market the goods and services that are similar to those that you previously sold. So if you previously sold a guitar to a customer, but you've also got a subsidiary that sells budgerigars, you shouldn't really be sending the marketing emails about budgerigars. Not really very similar to the product they previously bought from you. Of course, when you collect those details, you've also got to give the consumer the right to opt out of this marketing. But importantly, that is an opt out that they have to tick rather than an opt in. And also, each marketing email that you send to them, to the consumer, you've got to give them the option to unsubscribe at that stage as well. And most of these marketing platforms will have an unsubscribe option that you've got to use. Again, why does all this matter? Why should you care? Well, the Information Commissioner's Office can levy fines of up to £500,000 for breaches of the PECR. And they can levy those fines against not just the company, but against the directors of that company personally as well. So just a recent example, Information Commissioner's Office recently fined Halfords, a well-known retailer. They fined them £30,000 because Halfords had sent about 400,000 unsolicited marketing emails to consumers when they didn't have their consent to do so. So these things are actively enforced. On top of that, the government are currently consulting on increasing the Information Commissioner's Office fines, maximum fines for breach of the privacy and electronic communication regulations. And they're looking to increase them from 500,000 to bring them into line with the GDPR level of fines, which, by way of reminder, is fines of up to £17.5 million or 4% of global annual turnover. So that's not happened yet, but that is very much on the horizon. And it's important to note that when the Information Commissioner's Office has these wider fining powers, they do tend to use them. So by way of example, just recently, Information Commissioner's Office fined a US artificial intelligence provider £7.5 million for data protection breaches. In that case, this AI provider was scraping images from social media to create a global facial recognition database. I mean, what they got fined for is not quite the point. The reason why I mention that is that when the Information Commissioner's Office has these big fining powers, they have definitely not been shy in exercising them. So if the fines under PECA go from 500,000 to 17.5 million, inevitably the kind of fines that the ICO will be levying will be significantly higher as well. So that just brings me back around to my closing remarks, which is essentially just to highlight the points I made at the start of the webinar, which is that this subject matter is dry. There's no getting away from that, but it is really important. It's important for your reputation as a business. It's important because it avoids you getting into legal disputes with your customers. We've not really mentioned that, but of course, your customers can sue you for this kind of stuff. We don't see it often. When we do see it, usually it's for fairly low value. But that in itself is problematic. If these claims are for a few £1,000s in the small claims court, where even if you defend it, you can't get your legal costs back, even if you win. A lot of businesses, they just haven't got the management time, they haven't got the resource to put into a claim of a few grand. They often end up paying it off. But more importantly, probably, is the points we made earlier about the very significant fines that are available and the potential criminal liability, not just for the company, but for you as owners and managers of those businesses as well. So if that doesn't prompt you to think hard about compliance, frankly, nothing really will. So that brings us to the end of the presentation. I did say I'd try and wrap it up in good time. I hope that you found it useful. If you've got any questions, then do feel free to fire them through. I've got a couple of questions. Where does the fine money go to? Who receives the compensation? Well, good question. It goes to HM government, unfortunately. Information Commissioner's Office fines go to them. Trading Standards, Competition and Markets Authority, that goes to them as well, unfortunately. Obviously, you've got to distinguish between fines from government bodies and you being sued individually in the courts by a consumer. When the consumer wins damages against you, obviously those damages will go to that consumer. We've got an email about attaching a PDF to email. So attaching PDF to emails makes them likely to be put in spam folders. Does the customer need to receive the email for this work Should we not just include the T&Cs in the body of the email to avoid the spam issue? Yeah, good question. I mean, ultimately, I think as long as you can show that you've sent the email, I mean, I'm not sure that you can really ever stop something going into a spam. You know, some spam filters are more twitchy than others. You know, alternatively, you can just include them in the body of the email. I say I'm fairly relaxed about whichever approach you take. I'm not too concerned if the attachment does go into the spam email, because you'll have a record of having sent it and I guess of it not being bounced back. I guess there's not much you can do if it bounces into a spam folder. That's probably more of a responsibility for the consumer, I'd say. I'm sure there's any other questions. Just perhaps another point, just in terms of what's on the horizon. There's some new legislation next year that might put some more legislation around subscription websites. So if you've got a subscription website where you're constantly getting a payment for an ongoing subscription, the laws around that are going to be tightened up next year. There's also going to be new laws around fake reviews on websites to look out for. That bill is still going through Parliament, so there's still perhaps a bit of to-in and fro-in to come on that. But you know, hopefully we've got your contact details and we'll provide you with some updates as to what that law is going to look like on subscription, what that law is going to look like on fake reviews when it comes into place, hopefully next year. So we've got no more questions. I think last thing to do is just to thank you for your time and to, yes, as I mentioned, if there's any queries, please let us know and we'll send out the slides fairly soon. So thanks very much from me and Tom. Hope you have a good afternoon.
Thank you.